Hello everyone, a very good morning. So this is the CAIIB Foundation series for the June 2025 exam, and we are covering the BRBL paper, all the units module wise. Today we'll be covering the unit 30 from module D, which is the Transfer of Property Act 1882. So this is a very old act in which we'll be talking about the sale of immovable property, the mortgage of immovable property, the different types of mortgage, what are actionable claims, everything. So make sure that you like the video, share it with your other fellow aspirants, and also subscribe to the channel so that you can have these updates. These daily sessions are very important for your exam preparation. All right. So when we talk about the transfer of property, the definition which is given in the act, it means by which a living person conveys a property in present or in future to one or more other living persons or to himself or to one or more other living persons. So living person will include a company or an association of body of individuals. Why? Because in the Companies Act we also studied that a company is a separate legal entity, right? It is not a natural person but an artificial person. So even a body or an association of individuals will also be included, right? Then here the provisions of the act do not affect any law applicable to the companies or the body or association of individuals. Every person who is competent to contract and entitled to transferable property is competent to transfer the property. All right, so this is what is meant by a transfer of property, right? Now, when we talk about the transfer, it can either be through a sale of immovable property or it can also be a mortgage. Both the things are different. In sale, what is happening? The ownership is being transferred after a consideration has been made, where a payment has been received by the seller, right? So, the sale of immovable property refers to a transfer of ownership in exchange for a price, which is paid or promised or part paid and part promised. Because we are talking about the property which can be present or it can also be future. Then the sale of intangible or tangible immovable property. Tangible means something which is physical and it can be touched for a consideration exceeding rupees 100 can be made only by a registered instrument. Why this rupees 100, you might ask? Why such a small amount? Because this act was of 1882. It is a very old act and rupees 100 would have been a big amount at that time. Okay. So the delivery of tangible sale can just connect it with the concept of sale of goods and agreement to sell. Sale simply means that, okay, the contract has been furnished. I will provide you the goods, you make me the payment. Delivery, however, will happen when the seller places the buyer in possession of the property. Now, the property has been given physically to the buyer. That is a delivery. So this is the meaning of sale of immovable property. It is different from mortgage. In the module C also we have studied the meaning of mortgage, the different types of mortgage. So mortgage is the transfer not of ownership but of an interest. Transfer of an interest in specific immovable property to secure the payment of money given by the way of loan or to secure the performance of an engagement which give rise to a monetary liability. So again, if a borrower, if a debtor is taking a loan from a creditor, as a security they're keeping their immovable property. So now the creditor will have an interest in that immovable property, that if the borrower defaults, then by the way of selling of the property the creditor can recover their loans, right? So here the transferor of the property is known as the mortgager. The transferee to whom the property is transferred, the possession is given, is known as the mortgagee. The principal money and the interest secured is called the mortgage money. The mortgage money will include both principal money as well as the interest. And the instrument by which the transfer is effected is known as a mortgage deed. So, in the very contract, if it is stated all the expressed terms and conditions, that will be known as the mortgage deed. So, this is the main difference between the sale of immovable property and mortgage. Again, every person who is competent to contract and entitled to transferable property or is authorized to dispose of the transferable property, that is, they're acting as an agent, they can enter into the mortgage deed. All right. So again, the transfer of property may be made without writing in every case in which a writing is not expressed in the law. So, who can be a mortgager? The absolute owner of the property, one or two of the co-owners, the karta of the Hindu undivided family, the guardian of minors' property, any executor or administrator, right? Let us just once again see the different types of mortgages that we have studied. We know about the simple mortgage, in which the borrower pledges the property as collateral but retains the possession without delivering the possession of the mortgage property. The mortgager binds himself personally. So there is a personal liability on the mortgager, that in the event of his failing to pay according to the contract, the mortgagee will then have the right to cause the mortgage property to be sold. Right? So he is personally binding to the mortgage money. Then we have the mortgage by a conditional sale. In this type of mortgage, you sell any property to us, but with the condition that the sale will become absolute. So in the beginning, it is known as the ostensible sale. Ostensible sale. Only if there is a default in the payment, then this ostensible sale will become absolute. On condition, when the payment is made, the sale will become void. And on condition, when such payment being made or the default is there, it will become absolute. So if the borrower makes the payment, the property will be returned back. Then we have the usufructuary mortgage. The borrower transfers the possession of the property to the lender. So there's a transfer of possession. Expressly or by implication, they bind themselves to deliver the possession. All right. So the mortgager authorizes the mortgagee to return such possession until the payment of mortgage money. They also have the right to receive the rents and profits which are arising from the property. Then we have English mortgage, the borrower to repay the loan on a certain day and transfer the property to the lender as collateral. Again, there is a personal liability to repay the mortgage money. Then we have the mortgage by the deposit of title deeds or equitable mortgage, where only the title to the property is kept as a mortgage. In particular towns, Calcutta, Madras, and Bombay, and any other stated by the state government. So the mortgager delivers the documents to the of the title to the immovable property. And the last is the anomalous mortgage, which is a combination. It is a combination of the two types, any of the two types of the mortgage. All right. So these are the different types. I hope you remember. And there are options with the creditor. They can sell without the court intervention, or they can also enforce the mortgage through the court, right? So, after the enactment of the Recovery of Debts Due to Banks and the Financial Institutions Act, which is also known as the DRT Act, the recovery of debts of rupees 20 lakhs and above can be commenced in the DRT. The DRTs and the DRATs that we have studied in the DRT Act, I hope you remember. And if the bank and the financial institution's advance is less than rupees 20 lakhs, and if they were secured by a mortgage on the borrower's immovable property, then the lender has to file a civil suit. All right. Then, what is the meaning of actionable claim? Actionable claim means any debt or to any beneficiary interest in the movable property not in possession, which the civil court recognize as giving relief, whether such debt or the beneficial interest be existing, conditional, or contingent. So, actionable claim means any debt on which the action can be taken by the creditor. There can also be a transfer of the actionable claim with or without consideration. It can be done only by the execution of an instrument in writing signed by the transferor. Signed by the transferor. However, there is no mandatory requirement of giving notice to the debtor before the transfer of the actionable claim. The transferee can also sue the debtor in his own name without obtaining the transferor's consent and without making him a party to the suit. So, this is the meaning of the actionable claim. So, that is all from this unit. I hope you understand the difference between the sale and the mortgage, the different types of mortgage. If you have any doubts and queries, you can put them down in the comment section. And you can join the CAIIB Super Elite plan, which is the all-in-one plan. You'll get live classes, mock tests, and the notes. So subscribe now and start with your preparation. That is all for today. Thank you so much. You can download the PDF of the session from the link given in the description box. And all of these videos, all of these updates are very important. So make sure that you subscribe to the channel as well. So thank you so much. I will see you again in the next session and all the best.